for session 3 of Working with Contracts. At this point, I will hand today's session over to you, Charles.
Okay. Hello, everybody. Thanks for joining. What I want to do, I want to get started, start with the contract that I asked you all to take a look at between last session and this one. And I'm just going to, so Jessica, let's go to the contract review layout if we could. And what I'd like to do with this is just go down the list of people who are participating. I'm going to ask you in turn to just share with the group whatever whatever comments you have. And if you remember, I said there was going to be a prize for the nitpickiest comment and a prize for the most substantive comment. Having said that, I'm just going to start with Alex. And Alex, just tell the group, and use the phone, not the chat here, a comment you have, and we don't have to go in any particular order. So just tell us where you're looking, and I'll bring that part of the contract up on the screen, and you can tell us what your comment is.
Sure. So I guess I'll just go in order. On the very first line where it says tons of fun at the end, there's a comma. And later on in section 5 in the definition, there's no comma before the word ink.
Okay. This is that's a really good catch, Alex. It's a nitpicky. It seems nitpicky, but when it comes to the names of the parties in the contract, you really have to double check and make sure they're right. Not only the names of the companies, but also if you have individuals' names, their names too. People don't like to see their names or their company's names misspelled. So, Alex, how do we determine which of these spellings is right, do you think?
I'd go to the Secretary of State website and look up the name.
Correct. The correct name of an entity is the name that's set forth in the original filing that was made by the entity with the Secretary of State. And there have been cases where there's a typo in that filing, but if it is a typo in the filing, then that's the company's name. Okay, next person is Charlie. What do you have for us, Charlie?
I think just to kind of follow right off of where Alex left off, I think the comma after Tons of Fun, Inc. Probably was intended to include a Delaware corporation, similar to how they did with Toys R Us Corp. So it should be Tons of Fun, Inc., comma, a Delaware corporation, open paren, buyer, close, comma, or no, you don't need a comma after, sorry.
I think you do, because if you put in here, if you put comma, a Delaware, and I'm going to shorthand, a Delaware corporation buyer, you need a comma there because a Delaware corporation is
right.
a modifying phrase. But so Charlie makes two really good points there. Number one, since here we refer to Toys R Us as an Idaho corporation, we should do it the same for buyer. There's not legally required to do this when you're identifying parties to a contract, but it's a good idea, and certainly if you're going to do it for one, you want to do it for both. And then as it relates to the comma, you never have a comma before an open paren. If you need a comma, it always goes after the parenthetical. Emma, do you have anything for us?
Oh, sorry, I'm having connection problems. Can you repeat that?
Yeah, just asking if you have any comments, any corrections to the contract.
So I'm going to jump around a little bit.
Sure.
But when I was looking just at the purchase and sale section, in delivery, it doesn't actually say how any of this is going to be delivered.
Right. In C, it says seller shall deliver the equipment to buyer. And you're asking, your point is how? There's not enough meat on the bones here, right?
Mm-hmm. When it becomes effective, for example.
Yeah,
so
when is the delivery and how is the delivery? How is the delivery made? So there's stuff missing here that needs to be in there to make this work. So that's a pretty substantive point. And Emma, I'm going to put you down on the list for this very valuable prize for the substance award. But you're only on the list. I'm sure we'll have some other people, and then at the end, I'm going to have to decide who gets it. So let's see who's next. Michael.
Sure. So if you scroll back to the top, there's a lot of nitpicky things.
Oops. Sorry. Yeah, go ahead.
The first whereas clause was spelled incorrectly.
Okay. Whereas it's spelled wrong, and how is it that that spell check didn't catch that? Do you think? Anybody know? Spell check. I'm told that spell check doesn't work, for words that are in all caps.
You can actually change that option.
Go ahead. I'm sorry.
You can actually. This is Emma. You can change that option in Word.
Ah, okay.
You can ask it to.
That's good to know.
Spell check all caps.
Okay. Well, you see, I didn't know how to do that, and then I got whereas spelled wrong.
Okay.
Riley.
There's also an extra space after equipment before the close.
Okay, there is. I'm gonna. There's an extra space right in here, if you see it. I'm going to ask everybody just to give one comment at a time. We're going to scroll through the list again, but I'm going to ask you to just do one. But since I didn't say that as clearly as I should have, I'm going to put Michael on the list for that missing space. That's a real nitpicky comment. So Michael's on the nitpicky list. Now we're going to move to Riley.
So I'll kind of keep in the same area. I was working on an equipment lease for a client when I actually went to do this a week or two ago.
Okay.
And so what I did was in that first whereas, the first recital, added some language after owns certain equipment to say specified on Schedule A attached here to, and moved the definition after that.
Yeah.
Because I wanted to make sure that the equipment was limited to a certain list and that it wouldn't change, so there would be no ambiguity later to what equipment this refers to.
Yeah. Oh, how effective do you think this language is as it stands to reflect the deal between the parties?
Basically as ineffective as possible, except that you know that there's something tangible that they'll be buying.
Yeah, totally ineffective, and Riley's going on the list for substance because, this not only is a failure in terms of having, the parties, agreeing to the main terms of the contract. I think it renders the contract unenforceable because it's not clear what the contract is really about. So that's pretty important. Now, if it was one piece of equipment, you could describe the piece of equipment here. But if it's multiple pieces of equipment, which I think it is in this case, the smart way to do that is just refer, as Riley suggested, to a schedule, which you can, which your client can prepare. Somebody else will have that list. You just slap that on to the contract as a schedule. Okay, next is Valeria. Valeria, are you with us?
I see that she's typing, Charles.
Okay, I guess she doesn't have she does not have a phone symbol there. So let me see what she's. Let's wait till she finishes typing. Oh, okay. She's typing. She's on the other line with a client, which we all know takes precedence. So I guess that brings us back. There's somebody else here, but I don't know whose name that is. So I'm going to skip over that because there's no name there, just a phone number. So we're going to go back to Alex and keep going here. Alex, do you have another one for us?
Yeah. So kind of the next one's a redundancy. It says the parties agree as follows. And then it says that the parties agree.
Right.
So in section 1A, I eliminated the parties hereby agree that, and then I just capitalized the O and on.
Correct. This is a common drafting. It's not a glitch because it doesn't really have a substantive effect. But in a contract, there's no reason to have this language that the parties are agreeing in this paragraph because they're agreeing to the whole thing. That's the nature of a contract.
Yeah.
Charlie, what else do you have for us, Charlie?
Yeah, if we jump just up to the last whereas, I think, it may not be entirely necessary, but since in the first whereas we said that seller is going to sell to buyer, I think we should say the buyer wishes to purchase the equipment from seller on the terms herewith.
From seller, yeah, just to be consistent. I agree with that. Emma.
In that same whereas clause, equipment should be capitalized because it's a defined term now.
Yeah. Once you've defined a term, you have to capitalize it. If you don't capitalize it, then you're not referring to that defined term. Without capitalizing it here, you'd just be referring to equipment as a generic concept, which is clearly not what was intended there. Michael. You have another comment for us.
Yes, in 1A, the 15 million, it's not clear what 15 million what. Is it Canadian dollars, Australian dollars?
U.S. dollars. So the way to address that is to put in U.S. dollars here. Now, in a contract, we don't know where the equipment is, I don't think. So if it's possible that the equipment may be somewhere outside of the U.S. I don't think it's always necessary to put in U.S. before dollar, a dollar sign. If you're dealing with U.S. companies and there are no international components to the deal, I don't think it's necessary, but it certainly doesn't hurt. And again, if the equipment, any of the equipment is either located in or being delivered to a non-U.S. location, then you'd certainly want that. Riley?
Yep. We were just looking in A, right? So I made a few changes to B, but they were more negotiation points. So I think the other ambiguity that I found next was in subsection C, where it says it shall be responsible for all costs of delivery.
Yeah.
So, I mean, that doesn't tell us which party is going to pay for delivery.
Yeah. It is ambiguous, and that's could be a pretty substantive and important point if the delivery costs are significant. So it's just probably looked at in an earlier session where you've got a pronoun that does not have a clear antecedent. So this needs either to be buyer or seller. I assume Valeria is still on the phone with the client, so let's take one more trip around through the list here and start with Alex again.
So I'm going to go back up to A again.
Yep.
The closing date, when you look at the definition, is about a year before the blank at the top of the purchase agreement.
Right.
The closing date is December 2013, and this is November 2014.
Yeah, so there's clearly some timing issues there. In the definition of closing date, if we're negotiating this contract now, you can't have a closing, either before the date you're negotiating the contract or before the date of the contract. So clearly that just needs to be fixed. Charlie.
Yeah, if we go back to 1B, I think we had some excess verbiage.
1B, yes.
Okay, so I don't think we need, so commencing on the closing date, I don't think we need it, and on every calendar day thereafter, I think we can get rid of that.
Yes.
I think we can also get rid of after buyer shall be subject to, and I think bear the risk of loss probably covers what we're trying to do there.
Yep.
And then after the first use of equipment, I think we can get rid of generally and as any and all specific items of. I think we've already defined equipment. We know what that is.
Yep. What about including without limitation the risk of fire and sand erosion?
Yeah, I don't know if there's anything particular in this deal that would, render that relevant, but we probably don't need it either.
Yeah, you don't need that. Now, sometimes you will see people negotiate language including without limitation, and the reason for doing that is it shouldn't ever be put in to change the substance of what you're saying, and because then you're just going to have confusion. But the reason people put this in there is just to drive some particular example of a particular concept home, so just to make sure that there's a meeting of the minds on that particular aspect of whatever it is that precedes it. But it's probably unnecessary here, so we're going to delete it. Thank you.
Sellers in Idaho, I didn't know if maybe there was going to be, they both knew it was going to be traveling by train, and there could be I don't know, but you're right.
Yeah, unless there's something very special, you wouldn't include that. Emma.
So let's see. Going down to, it's probably giving, but into little a, the font is different.
The font is different. Yes.
So, and the spacing is different on all three of those.
Yeah, the space, the margin on the right is different. Starting with A. Emma, how do you think that happens in a contract where the font suddenly changes like this?
I mean, it usually happens when you when you copy something from a different contract and paste it in, and then don't use your little format painter guy.
Yeah, exactly. You didn't paste it in a way that adopted the format of the document into which it's being pasted. So this is just a copy and paste that wasn't done very carefully. And when you copy and paste language from another contract, you need to not only make sure that you're following the formatting of the document that you're pasting it into, but you also need to pay attention to make sure that everything in that language, things like defined terms and other things, are match up to the contract into which you're incorporating it. Michael.
In that same subparagraph, you don't need the A in the parens in the right before bankruptcy because you're not well, at least the way it's written, you're not separating them out into separate items.
Yeah, there's no need for the subclause A because there's no subclause B. Now, typically in this representation on enforceability, there is a B, which is what we call equitable principles. And just so you know what these two exceptions are in the concept of enforceability, these are very standard. The rep itself, and you also see this language in legal opinion, is basically saying this contract is enforceable. It works as a contract. It can be enforced by the other party. But then the qualifications exclude bankruptcy, and the reason for that is because in bankruptcy, the automatic stay that takes place in bankruptcy specifically precludes parties from enforcing their rights under the contract. Instead, they just have to pursue their claims in the bankruptcy case. So that's the reason for the first qualification. The reason for the second qualification of equitable principles is to take into account that with a contract, you can't always get a court to give you specific performance. That's an equitable remedy that a court can decide to grant or not to grant. And so that's why we say the contract is enforceable subject to equitable principles. You can't always get the court to exercise its equitable jurisdiction. I believe we're up to Riley.
So I looked at, in Section 3, there were a few things that I thought were kind of extraneous here, but, the prompt said to make sure that any negotiation stuff we did was fair.
Yeah, what do you think is not fair here?
In 3B, I just figured that we were going to get pushback on good and marketable title to all of its assets, and honestly, as the buyer's counsel, I don't really care if they do. I just care that they have good title in the assets I'm buying, which is the equipment. So I just changed all of its assets to the equipment using the capitalized defined term.
Yeah, my only problem is I'm looking for where that you're looking, and I don't see it.
Or, sorry, I think I renumbered. Maybe it's old section 2.
Oh, section 2. Okay.
2B.
Oh, yeah. Okay. You know why I didn't find it? Because the heading is also screwed up. It says environmental liability, and I just tricked myself there. Yeah. So you're absolutely right, and this is a substantive point. So Riley's going on the list for this one, Jessica. Look at this rep. Seller has good title to all of its assets. Is a buyer entitled to that kind of representation from the seller? The answer is no. Why? Why is it any of the buyer's business what title seller has to any of its assets other than the equipment, which is the subject of this contract? So, what Riley's doing is exactly the right to change, is to just limit it to the equipment, and obviously also change the heading. Now, headings are not intended to be a substantive part of the contract. They're just there to help the reader. But what just happened to me is an example of why we should take some care to make sure the headings are adequate as guideposts for the reader, because if they're not, then people just get confused and it's hard to find things. All right, let's go through the list one more time, the list of participants. So one last comment from each of you. Alex, why don't you go?
I'm still up on A.
Okay.
we need to underline purchase price to make it match all the other definitions.
Yes. Now, that's true. Notice that the format of this document is that defined terms that are defined in the text, are underlined. That's not a requirement, obviously, but if that's the way this contract does it, it needs to be consistent. So we're going to underline all the terms that are defined in the text. Charlie.
Okay, returning to 1C, I think we need to know when the seller is going to deliver the equipment. Did we already get that?
Yeah, somebody already covered that, so why don't you give us another one?
Okay, here's a nitpicky one. I think since we use capitalized agreement about halfway through, I think we probably should refer to that in the definitions, but more likely up in the preamble, maybe after stock purchase agreement, say this agreement, define the term.
That's the customary way to do it. You would say this agreement after you refer to it. How about you spell this correctly? Emma.
And Charles, it looks like Emma just sent a note that she's getting pulled into a call with a client and she had to disconnect, but she'll be back.
Okay. Michael?
Sure. Well, one nitpick I would actually go back to is 1A, and I would put periods between U and S, because otherwise it just says us.
Okay. So you're correcting my correction. We're going to put Michael on the nitpick list for nitpicking my earlier correction. That's high level nitpicking. Thank you. Riley, one last comment, and then we're going to shift gears.
So I guess in the provision after where I was talking about before, section 2C, it looks like.
Mm-hmm.
Same with manufacturer warranties. I thought there was just some extraneous or some extra language there, so I took out take all actions necessary to, and just said seller shall assign the manufacturer warranties.
Take all actions necessary to doesn't add anything.
Right.
You're either going to do it or you're not.
Right.
One other thing, just while we're here, one other thing about this clause is that this is in the wrong place. This is not a representation and warranty because it's not a statement of fact. Instead, it's a covenant. It could either be written as a covenant or as a closing condition, but it's certainly not a representation and warranty. Now, does that mean it doesn't work? No, it doesn't mean that. But once again, when we're working with contracts, one of the things we're trying to do is to make them user-friendly, keep them such that you're not going to have a hard time, the reader's not going to have a hard time finding things or reading the contract. And one of the main reasons that we spend some time making sure that everything's in the right place and that everything reads as simply and clearly as it can is because you guys are the ones in the future who are going to be called on to review these contracts after they're entered into, to advise the client, to advise your partner what the contract says, to read them to see if there are any conflicts that could come up in the future. And so if you're the user of the contract, you're going to appreciate the extra time you took when you were working on the contract to make it user-friendly, to make sure that the headings are right, to make sure that the table of contents works properly, to make sure that all the schedules and exhibits are listed, just to make sure that it's, you know, as handy a tool as it can be. So that's just a good thing to keep in mind. Okay, so thank you for your comments. You all did good. Now I'm going to, Jessica, let's go back to the main layout, and I want to take a look at our list of Riley. I think I'm going to award the substance award to Riley. He got the one about the equipment not being defined, which is a very important point. So Riley's going to win the substance prize, and let's see. And then for the nitpick, I'm going to award that to Michael, who corrected my correction. That's a real step up in the nitpick department. So you're each going to get a valuable prize, which I'm going to be sending along to David Simon, who's going to then distribute them to the people. David, I'll send them to you and remind you who they go to. And there's one more prize that's going to be awarded in addition to these two prizes, which we've dealt with before, and that is our excess verbiage contest. And here we have another one of these as we're going into the last half of today's session. What excess verbiage is in here? And remember, if you want to answer, you have to type the word cut into the chat box and hit enter in order to get your, basically press the buzzer here to give your answer. So I'm looking for someone to tell me what words we can cut here. Charlie, what would you cut?
I would cut significant.
Significance. That is correct. Whoops, that's not what I wanted to do. There, significant. Why would you think that significant doesn't belong here?
Well, it doesn't seem to be defined in this case, but I think material adverse effect is a term of art that doesn't need to be qualified by significant. That is, the significance is the material adverse effect?
Yeah, the word material and material adverse effect is really a synonym for significant. Significant and material both kind of cover the same concept, which is how big is it, how important is it, and if there are other locations in this contract that have language about a material adverse effect on lessee's business or financial condition, and Charlie, if in those other locations the word significant doesn't appear, but it does appear in this location, what is that going to allow somebody to argue as to?
Yeah, somehow the other references are diminished.
or that this reference has got to be more material
Right,
or more
right.
significant than the others.
Right.
So this is a case where an excess word like this could actually create a basis for an argument for somebody to argue that the words mean something other than they were intended to mean. So Charlie, Jessica, let's make sure Charlie gets another point on our anti-windbag award. Okay, so what I want to spend the remainder of the time talking about is contracts and due diligence. And I'm guessing that many of you have been doing due diligence assignments, and a big part of what first years are asked to do in due diligence is review contracts, review existing contracts that one of the parties to the new transaction is a party to. And I also know that it's sometimes the case that the senior lawyers who give you your due diligence assignment and tell you to go and read everything in the data room don't necessarily give you 100% clear guidance on what it is you're supposed to be looking for. There have been stories I've heard about partners telling junior associates, just look for anything out of the ordinary, or just look for red flags, and of course that doesn't help you at all. So what I want to spend the rest of our time on is focusing on one specific aspect of due diligence that is a major part of reviewing contracts, and that is looking for potential conflicts between contracts. And this language that you see here on the slide, on this slide, is language that's included in most deals in the reps and warranties made by one or more of the parties. It's also the subject of legal opinions in many, many cases. And essentially it's a conclusion, and this is what this issue is all about, the issue that I'm about to talk about. It's all about, if a party enters into this contract that it's currently in the process of negotiating, in the current deal, when they enter into that contract, is that going to result in a breach or a violation or cause a problem under any existing contract? So this is something that you're always going to be on the lookout for as you're reviewing contracts in due diligence. Now let me put a little more meat on the bones here to explain what I mean by this. And I'm going to do it with some diagrams. So Party A and Party B have an agreement, let's say they entered into this a year ago, in which Party A has agreed not to do something. It doesn't really matter what it is. I call it X. But they've agreed not to do something. They've covenanted not to do X. And that contract, it's an existing contract. Now Party A is negotiating a contract, a new deal with Party C. This is the new deal that you're going to be doing due diligence on. And in that deal, Party C, the first draft of the contract that Party C has prepared, Party C wants Party A to agree to do X. If we allow Party A to enter into this contract with Party C, we are going to have a conflict, and that's because Party A has agreed to do inconsistent things under these two contracts. Party A has promised not to do the thing with Party B, and it has agreed the opposite with Party C, and there's no way that it can comply with both of those contractual promises. This is the problem we're trying to avoid, and every deal pretty much involves some thought being given to this question. And one of the things, as I said, that you always should be on the lookout for as you're reviewing existing contracts in the context of a new deal is, does any of those existing contracts, in this example of the contract between Party A and Party B, do any of those existing contracts restrict Party A from entering into the new agreement or from performing its obligations under that new agreement? What could X be? Well, X could be anything, but here is a list of some of the things that are pretty common in terms of the kinds of conflicts we're talking about. Let's look at the first one, incurrence of debt. So going back to our diagram, if Party A and Party C are entering into an agreement whereby Party A is agreeing to borrow money from Party C, they're agreeing to incur debt by borrowing money from Party C, then you know that one of the things you're going to be on the lookout for in Party A's existing contracts is, has Party A agreed, covenanted, not to borrow money, or has it agreed to limitations on its ability to borrow money under any of its existing contracts? And that's just one example, and there's really no limit on what X could be. X could be pretty much anything. And this, hopefully this illustrates why it's so important when you're doing due diligence to understand as much as you can about what the new deal is. What is Party A agreeing to in this new deal? What are they doing? What are they buying? Are they selling? Are they borrowing? Are they guaranteeing? You've got to know as much as you can about what Party A is doing, because only then can you do an effective job of reviewing these existing contracts to see if there's anything that's going to restrict Party A from doing what it's required to do under this new contract. And this is another shortcoming, unfortunately, of the way due diligence assignments are often given to first-year associates, which is not only are you not told necessarily what you're looking for, you're also not given, perhaps not given as clear guidance as you could be about what's going on in the new deal. What's this deal all about, and what are the parties doing? Okay, so let's talk about some of the reasons we care so much about this. Why would letting Party A enter into this contract with Party C be such a problem? The first issue is if we allow Party A to agree to this, Party B then has a claim for tortious interference against Party C. And if you think that's just kind of an academic possibility, let me describe to you a case that was reported in the New York Times a year or so ago involving Martha Stewart, JCPenney's, and Macy's. In that situation, Party A was Martha Stewart's company, and Party B was Macy's. And Martha Stewart and Macy's had an agreement in which Macy's had an exclusive right to sell Martha Stewart homewares in their stores. But the contract between Martha Stewart and Macy's, which gave that exclusive right to Macy's, there was a qualification to that. There was an exception which said that Martha Stewart could sell homewares in a Martha Stewart store. Okay, so that's the existing contract. That's the Party A, Party B contract. And that's in place, and suddenly Party C, which in this example is JCPenney, shows up and they knock on Martha Stewart's door and they say, Martha, we would love to sell some of your homewares in our stores. And Martha Stewart says, well, we can't really do that because we've got this contract with Macy's. And Martha Stewart and JCPenney together take a look at that contract and they come up with an idea. And so they enter into a contract, and pursuant to that contract, what JCPenney does is on their sales floor, they erect a little building. This is like on the second floor of JCPenney's. There's this little structure. And they put a sign on it saying Martha Stewart store. And they start selling homewares in the Martha Stewart, in this quote-unquote Martha Stewart store. And Macy's immediately objects. Macy's sues Martha Stewart for breach of contract and sues JCPenney for tortious interference with contract, alleging that JCPenney, by entering into this contract, is inducing Martha Stewart to breach the Macy's contract. And of course, JCPenney takes the position, well, it's not a breach because this is a sale by a Martha Stewart store, for which there's an exception in the contract. So these articles in the New York Times, which I followed pretty closely when they were coming out, there was some pretty entertaining stuff. For example, the cross-examination by the Macy's lawyers of the JCPenney executive, where the JCPenney executive was asked, okay, this Martha Stewart store that's on your premises, it's obviously constructed out of wood and plastic and materials and so forth. So who is the owner of that building, of the materials that make up that building? Does JCPenney own those? Does Martha Stewart own those materials? And of course, the executive from JCPenney had to say, no, we own those materials. So then the next question was, okay, all of the Martha Stewart homewares that are in that Martha Stewart store, those are all owned by Martha Stewart, aren't they? And the executive had to say, no, they're all owned by JCPenney. And the questioning went on along those lines. Who are the employees who work there? Whose cash registers are there? Et cetera, et cetera. So through this testimony, it became abundantly clear that this was not a Martha Stewart store. This was JCPenney dressed up as a Martha Stewart store, and the case did not reach a conclusion because halfway through, after some of this testimony, the case was settled, and JCPenney stopped selling this stuff. Clearly, they had a losing case here, and I found it kind of surprising, quite honestly, that whoever advised both Martha Stewart and JCPenney thought that this was a good idea. And this is just an example of something that lawyers do which they shouldn't do, because we as lawyers, we believe in the power of words. Words can be very powerful, but sometimes lawyers will get carried away, and they will think that they can change reality with words, and you can't do that. You cannot change reality with words. You cannot make something a Martha Stewart store just by putting a sign up on it and saying that it's a Martha Stewart store. Whenever you hear lawyers or anyone else talk about deeming things, like they'll say, well, let's deem that payment to be the payment of a management fee. What that means is we're about to start engaging in fantasy. We're about to call a dog a cat. And sometimes that's okay, but you always have to be aware of the fact that at the end of the day, certain people like the IRS and a judge are not going to be convinced by the names that we give things. They are going to look through the names and look at the substance. So anyway, I like that story because I think it's a pretty interesting illustration of how if we have a second contract which conflicts with an existing contract in the way that I'm describing, one of the problems is there's a potential claim for tortious interference. The second problem, potentially, is that Party A could very well be in breach of this second contract ab initio, from the moment it signs the contract. Not necessarily, but in the kinds of deals you guys work on, I would guess most of the time, Party A will be in breach right away. Why will Party A be in breach? Well, Party A will be in breach, and I'm just going to backtrack here a little bit, if Party A has given this representation that we looked at earlier. And now that we're talking about this, take a look in the deals you work on, take a look at the reps and warranties and see if there's a rep like this by all the parties, and you'll find generally there is. So if Party A is given this rep, they're going to be in breach of that rep and therefore breach of the contract the moment Party A signs. And this is also the subject of legal opinion. So hopefully Goodwin Procter has not given a legal opinion to the same effect, because if they have, that opinion is wrong, and that could be a problem for the law firm. And that's, again, one of the big reasons that you're doing due diligence on these existing contracts is to support this rep and also to support the legal opinion that there's no conflict between these contracts. Another problem with this kind of situation is that this second contract might be unenforceable. You might not be able to enforce the contract, or Party C might not be able to, and or might not be able to enforce the provision that deals with X. In either case, that's a bad thing, and also that could give rise to opinion issues. This is a result that not all lawyers know about, but in fact there's case law. Sorry about that. There's case law and there's language that we see here in the second restatement of contracts that makes it very clear that in a situation like this, the second contract, or at least the portion of it that creates the conflict, is unenforceable. Charlie, what would you do here?
Well, I think we might be able to get by with the company shall not sell any assets except the specified securities.
Yes, sir. That's exactly what we can do. All that other language is roundabout and unnecessary. What we're left with here is a much more typical and appropriate approach, which is you have a prohibition, which is the company shall not sell any assets, and then a list of things that they can sell, which in this case is just specified securities. To say, you know, except that the sale of securities shall not be considered a breach of this section 5.2, that's just very roundabout, and there's no need to say it that way. So, Charlie, you get another point towards the anti-windbag award. So what I want to do now is look at a few examples of contract provisions and examine whether they're likely to cause a conflict with existing contracts of one of the parties. Now, obviously, we can't answer this without looking at those other contracts, and we don't have time to actually do that here. So we just have to assume that the other contracts that the parties to this contract that we're seeing this language from are typical. So just take a minute. This is a provision in a lease. And just think about it for a minute. Is this likely to cause a potential conflict with other leases to which the lessee under this lease is a party? So I'll just give you a minute to read this language and think about that. And if anybody has would like to talk about that or chat about it, that's fine. And if not, I'll just if you've had a chance to think about it for a minute, I'll just speak to that issue. Well, this pretty clearly is going to create a conflict because this language says that if the lessee fails to make its payments, its rent payments under this lease, it's contractually prohibited from making rent payments under all of its other leases. Now, obviously, if you're the landlord under this lease, you would love to get this provision. And you know, a business person might view language like this as what we sometimes call schmuck insurance, meaning, hey, if this tenant isn't paying me, I'm going to look pretty stupid if the tenant is out there paying all of its other landlords. So I don't want to be discriminated against, and therefore I want a provision like this. But we can't put that in the contract. We can't satisfy our client's desire for a language like this because of all the problems that we talked about earlier. So this is a classic case of a potential conflict. Now, of course, we would need technically to review all those other leases to be 100% sure there is, in fact, a conflict. But unless those other contracts say the tenant has to pay rent unless it's in default under this contract, then there's going to be a conflict, and for that reason we can't permit a client to agree to this or to ask for it. Here's another example. Take a minute and see what you think about this one. So this is what we call a PIK, or pay-in-kind provision, the first provision, where under the mortgage, the company can pay cash, make cash interest payments, or make interest payments by, essentially adding to the principal amount of the mortgage. And then when we say we're issuing notes, essentially that is just adding to the principal amount. That's why we call it pay-in-kind. So it has the option to do that under this mortgage. And now it's negotiating a new agreement in which the counterparty wants it to agree to make interest payments by issuing notes. Is that a conflict? No, it's not a conflict, because if Company A complies with this new provision, it's not going to violate that existing mortgage because it has the option of paying either in cash or notes. All this second contract is requiring it to do is to exercise its option under the pre-existing agreement, and there's no reason it can't, can't tie its own hands that way if it wants to by agreeing to this language in the new contract. This is the last example. This one is a little tricky. So I want you to review it with that in mind. It's not there. It seems like there's an obvious conclusion, but there isn't. So take a minute and read it and think about it, and then we'll talk about why the answer is a little tricky here. Okay, so and this is a very common type of potential conflict issue, and it's one I mentioned earlier, where a company is doing a borrowing and has one or more existing covenants which restrict its ability to borrow additional money. So it's proposing to enter into this $100 million revolving credit agreement under which you could borrow up to $100 million, but it has a covenant. Let's say this existing language appears in a bond indenture, and there's a broad prohibition against incurring debt, and of course we're going to look at the defined term debt to make sure that it covers the kind of borrowing that the company is proposing to do, but let's assume that the term debt does include this kind of borrowing, which it normally would. So we see there's a very broad prohibition against the company issuing debt or incurring debt, but then there's a number of exceptions, and none of the exceptions really apply except F. And F is what we call a basket, which is an exception that's denominated by a certain amount of money or a certain, quantifiable amount of activity. And it's a $200 million basket. So our first instinct is to say, hey, this is great. They have room to do $200 million of borrowings. So we're in the clear here. That is not the correct conclusion. Why isn't that the correct conclusion? Because notice that it says $200 million of debt at any time outstanding. So the issuer, your client here, could have debt on its balance sheet currently that it incurred in reliance on this basket. So we need to ask the client here if they have any debt like that. Have they used up any portion of this basket by borrowing money that's still outstanding? Because if they come back and they say, yes, we borrowed $150 million for financing of real estate, and that is still the $150 million is still outstanding, then this basket is really not a $200 million basket, it's only a $50 million basket. So just an example of the kind of, as you're doing due diligence, you're going to see things that are going to require further inquiry. This is an example of that. Okay, we're out of time, so I want to open this up to any questions you might have about things we talked about today or anything else that we've covered. I also want to see who has won the anti-windbag award. Charlie. So Charlie, we've got 3 winners here. The Nitpick Award is going to Michael. The Substance Award is going to Riley, and the Anti-Windbag Award is going to Charlie. And that is, as I said, those are all going to be coming. And I've been telling you they're very valuable. I have to confess, they're not Starbucks gift cards, but you can buy a drink for them. So I will. I appreciate all of your time and appreciate all of you participating. And if you have any questions, you can ask them at this point. And if you think of any questions after we're done, you can feel free to get in touch with me and ask. I'm happy to do that extracurricularly if that works for you. But you're all free to go now. I will stay here for a minute or two just to field any questions that might be coming. And otherwise, I hope I have the chance to maybe actually meet you in person someday or work with you in the future. And I want to thank David, Simon, for bringing me in and allowing me to do these sessions with you. Thanks a lot.